We're so happy. Oh, sorry. Yes, recording in progress. Good to see our panelists here, Jackie Claire, Sherman Kreiner, Ken Carlson from Winston, and Tara Kozlowski. We would like our executive director. I'd like to start with Tara to expound further on her latest missive about artificial intelligence. I know we touched on it, Tara, at the annual meeting, but if you could just sort of tell us what your message was about and where you are. Maybe it's changed even today. So I give the floor to you, Tara.
It may have changed since the last time I made the post. So just so you all know that I typically do not respond on the NCBA chat group because we don't have staff to monitor it, but every once in a while something will pop up and some really nice mediator will bring it to my attention that I should probably join the conversation. So I try to kind of allow that to be your space. But I did jump into this one because it is a hot topic. It's something that the commission has discussed over and over and over again in multiple committees, trying to figure out how mediation is going to work in the world of AI. Because it's such a hot topic, you all are about to receive the March newsletter from the commission that has updated Advisory Opinion 43 to speak directly to the mediator's responsibility regarding AI. Obviously, you can't control the world, even though we would all like to have that power. We don't. But you can control your own settings as well as providing information to the parties that are joining in that Zoom or remote mediation, right? So the commission, what we've done is instead of creating an entirely new advisory opinion, we've basically updated and added language to an old one. And the one that we chose was the ability or inability to mine metadata and record the conference through closed captioning on remote technology. So we expanded the advisory opinion to talk about the mediator's responsibility to ensure that AI is not operational during the remote mediated settlement conference. The mediator is responsible for hosting the mediation if they are doing it remotely on any platform that they would like to work with, and also for checking the box or unchecking the box, whichever it may be, to ensure that the conference itself is not being recorded or the note taker is not on. Every program has a different name, title, way of phrasing it, but basically you want to make sure that AI is not participating in that conference itself. The mediator is required to point out under Rule 6 that Rule 4 states that the parties may not record the conference itself. Interestingly enough, one of the responses to the comment I posted, and I'll totally throw Kathan under the bus because we had a great conversation about it later, is he said that Rule 6 really isn't needed. And I said, I agree. Rule 6 is kind of aspirational in the sense, and this is the advising the party that there's no recording. It's aspirational in the sense that the rules already exist for no recording of the conference. So it's redundant at best, right? The problem is, even with the rules of evidence precluding negotiation, communication to come into trials and hearings, personally, I can say, I'm not going to say this globally, but personally, I can say I've been in front of a variety of judges who view the rules of evidence differently than I did, right? And I'm trying to say that cautiously, but what we're doing is we are being redundant on purpose with the goal of, look, the rules of evidence say it can't come in trial, right? And then you've got the confidentiality of the mediator, and then you've got the no recording that is required under Rule 4, and then you've got the mediator who's saying to the parties, no recording under Rule 6. And hopefully at the end of the day, everyone kind of picks up on the fact that, wow, these conferences really should not be recorded. AI is a fabulous tool. I understand why everybody wants to use it. Every time I walk into a doctor's office, the first thing they say is, I'm going to use this note taker to take notes so I can record what's happening, right? But unfortunately, in the mediation session itself, AI is not supposed to be on. Whether it happens or not, you only have so much control over other people and their actions. Your responsibility is to make sure that the platform itself is not utilizing AI and that you have advised the parties and their attorneys that they may not or shall not, cannot, are prohibited from using AI as well. How's
Uh,
that for a start?
that's great. That's great. Tara, what do you do if well, first let me go to Sherman on this. Sherman, if you're the host, no one else can record, right?
That's my understanding. And I've kind of played around with it a little bit. I think I mentioned this at the CLE was that there had been an update a couple months ago, or I don't know, probably 6 months ago or whatever. And I found when I was starting my mediations, it was kind of defaulting to recording. And it was not the easiest process in the world. I mean, you can manually turn off each meeting, but you can dig through your Zoom default settings to try to turn it off. But it still felt like about 10 or 20% of the time it wanted to try to still allow the recording. It will give a notification to the participants. And so the few times it may have been by default on, or I had missed it to turn it off, somebody might say, hey, it's indicating that it's on. But it's one of those things I think you've got to be rigorous with checking to make sure it's not somehow default setting up. Now, again, that's with Zoom. I do a lot of longshoreman mediations too. And a lot of times they want to use Teams. And so just make sure, I think a lot of times we default to talking about Zoom, but there are other platforms out there that people use, and they may have different settings and stuff set up.
Great. Ken, can you weigh in on this for us? Has it been
Nothing more than really what's been said.
all right,
I'm
good.
very careful when I do my Zoom mediations. Not only do I've always given a just a condition that it can't be recorded, and I've turned off the recording function for the Zoom platform, but I've added to that now AI note taking and things like that as well.
Very good. Jackie?
Yeah, and they have, in regard to, we have to make sure note recording is turned off. You do have note takers trying to join the meeting, it says AI note taking, or AI translators trying to join the meeting. And that is a note taking type of device. And I don't let them in. And I'll say something to the folks that I have let in that, this is trying to join. And some of them have no idea that their device has that turned on so that it's trying to join. And they're like, oh yeah, no problem. That shouldn't be joining. And to add to what Tara had to say, I think one of the comments on the Bar Association listserv type thing, was just talking about, it's kind of common anyway. And that's true. I mean, we can't figure out if folks are just kind of reporting it with their phone, recording it with their phones, maybe that they have it turned on. And I think we've always, had to worry about that, even when, when we do an in-person mediation. And that's why I think, redundancy is a great thing. I mean, when I was in person, I had an attorney, he had this recording device on a necklace type thing, and he was kind of holding it out. And I said, what is that? And he said, oh, I'm recording this. And I was like, well, you can't record it. This was before we were supposed to, include that in our comments. And he's like, well, yes, I can. And then it was just really handy to have that rule, memorized, and pull that up and show folks if you need to. And so, it is, here. And I think another factor that we need to think about is that, confidentiality is so important. And part of the reason we have that is so that, we're not chilling the process. We want folks to be comfortable talking to us. And I mean, I even, Kyle just turned on, this is being recorded, and so I'm like, oh, and I just don't, I don't want to, I mean, sure, I need to be careful about what I'm saying. Um, but I don't know, it just adds something that you just feel uncomfortable when you know you're being recorded.
Exactly. Tara, anything else from the commission that we need to know about today that's going on?
Not regarding AI. I think
Okay,
the advisory opinion that we're going to send out shortly, it really sums it up. One thing that I have been asked quite a bit is, can the parties use AI? Absolutely. They just can't record the mediator being in the session with them, right? But if they want to type in questions to AI and not actually record what's being said, that's fine. If you walk out of the room and they want to use AI to try to come up with language, if you've got pro se parties, that's fine. If the mediator wants to separate themselves from everybody and say, hey, AI, I can't think of anything else. It's been a rough day. Here's where we're at. And they want to get information to try to figure out how to bring more items or options to the table, that's fine, right? So AI can be very, very useful. It just cannot record what's happening.
great, great. Thank you so much. Our next session in June is gonna talk about technology not involving AI, but who knows, between now and June, something may come up. So Tara, thank you so much. Anybody on our call today have any questions or comments before we move on to the next topic?
Um,
Hey, George, thank you. I have my hand up. This is Deb Dillman. I
Hey,
just
Deb.
it's sort of a strange question, I suppose, but I understand that, we need to comment about recording. But in the family law space where I and a few others on this call practice in, we still have quite a few unsophisticated people crossing in through our doorway who may not have even thought about recording anything until we raise the issue and then could potentially become a little sneaky about it. So I'm wondering, how much detail do you suggest? I guess this is for Tara for the DRC. Like, how much detail or comment or time do we need to spend on this so that I don't open Pandora's box and have an issue going forward?
Good point.
I'll happily jump into this. So I had to pull up the rules because I read them every day. I still like to reference them. 6B1J requires the mediator to let the parties know that the fact that Rule 4E prohibits any recording of the mediated settlement conference. So you're technically required under the rules to at least mention that recording is prohibited. How far you want to dive into that is really up to you. Mediators have a lot of autonomy because you all know who you're working with. If you see somebody walk in with their phone and touch it and then set it down like in the middle of the table, obviously you need to take it a little bit further. If they're just sitting there, no devices out or whatever, I think just indicating that recording is prohibited is plenty.
Yeah, most of my cases now, folks are bringing their laptops, and I don't have the opportunity to see the laptop. I see the back of it, so I can't see what's happening on the other side of the keyboard.
I mean,
So,
if they're bringing a laptop, clearly they're sophisticated enough to have the ability to record. So I would make it crystal clear that if they are using a program, even a Word document potentially that could have some kind of note-taking device enabled in it, that they need to turn it off.
George,
Yes.
I have a question for Tara. I have added that comment to my opening. You're not allowed to record, even with AI. And there's that other little piece in the back of my mind that I never say, and it gets to Deb's point. If you do record, you could be held in contempt. Obviously, the mediator is not going to do anything about that, but I guess the other party could do that and could file a motion for contempt. There's a part of me going, and if you do, you could be held in contempt. And then it's like, so I don't ever add that. But I don't know, Tara, what are your thoughts on that?
Well, the DRC doesn't regulate the parties' behavior, but the court certainly can, right? And so when parties behave badly at the mediation, it really depends on how hot the other side is about that behavior if it becomes known, if they even know about it. I mean, one of the things the commission is taking into consideration over the summer at committee level is if a mediator has the ability to share with the other side that the rules have been broken, right? And recording is the issue at hand. So if the mediator finds out the party A has been recording the entire session, right? And they say, but don't tell the other side that you caught me, is it legitimate for the mediator to be able to say, unfortunately, that is not covered under confidentiality. You violated the rules. I'm going to let the other party know. And then we're going to sit down and figure out how to go about it, right? I mean, we all know that the mediator has to protect the integrity of the mediation process. So at that point, if a party is recorded and they're refusing to delete or remove any of the recording, then the mediator should impasse the case to protect the integrity of the mediation process, right? But what happens if the party says, I'm going to keep the recording that I have, you are bound by confidentiality and can't tell the other side. So go ahead and impasse the case, and I'm going to use this any way I see fit, right? Is that fair to the other side? So that's the question that's come up, and I don't have an answer for it right now. I'm just letting you know that that's something that's developed because recording has become such a hot topic and such a
Well, I guess I'll kind of go back to that, for that, I don't know if that occurred. I think I might just, say I have to pull out because of conflict. I don't know. I mean, that'll be interesting to see what y'all decide. But just back to, if in the opening you said you're not allowed to record, and if you do, you could be held in contempt, or, I think that would get to Deb's point of a deterrent, really, because it's unlikely we're going to figure out that they're recording. If they're surreptitiously recording on their phone and you can't see it until they try to take it and play it for the media, or rather than just court. And I don't know, just if that is a better deterrent to mention that you could be held in contempt. But on the other hand, man, that is just kind of heavy-handed, to start a mediation process when you're going, hey, you could be held in contempt. So I don't know.
I think presenting the idea that they could be held in contempt also kind of borders on legal advice.
Well, that's a good point.
Right. So not only is it heavy-handed, like, hi, welcome to my mediation. We're going to work together and focus, but don't violate or,
that's right.
in front of the judge getting yelled at. Right. So that's.
Well, I'm glad I haven't been saying it.
Right. But then, I think that, it's possible to say, that there are Supreme Court rules, right? So instead of putting the emphasis on the violation, put the emphasis on where the rules come from. Kind of give it a little bit of teeth from the backside, saying, I appreciate that you all are here. I love this program. It's a program that's issued, the rules are adopted by the Supreme Court of North Carolina. They take it very seriously. There's a few rules that I have to go through with you to make sure that you understand the process. And hopefully they will absorb that information and understand that they should not violate those rules. But who knows?
Yeah, I think setting the tone, Jackie, is so important, and doing it from the beginning. And I think in the atmosphere, even remotely, there is sort of like walking into the courtroom, there's just hopefully that permeates the process. It's a great discussion. Yes, sir.
George,
Sherman.
can I make another comment real quick?
Yes, please.
Is I think in this setting we're all attorneys, or the majority of us are attorneys, and I think when we do have the mediations and we talk about the confidentiality involved in mediation, we're continuing to educate the attorneys who are handling cases out there. I mention all that because I do a lot of mediations with AAA as well, and we had a huge roundtable maybe a little bit over a year ago, and there was several hundred mediators on there, and I noticed during that call that several of them just kind of casually mentioned that they recorded their mediations. I never was real clear why they did that. I don't know if they were trying to review them to get feedback of how they did or something like that or whatever. But the impression I got from them was that most of them were not attorneys. And again, it's nationwide, and so I don't know what states they were. I know afterwards, and Tara, maybe you can comment on this, that I think it's pretty much nationwide that there's a confidentiality provision in the mediation rules. But I don't know if there's any states that allow for it. I can't imagine. But the little bit of research I saw did not indicate that there were states out there that allowed any recording from mediation. But my point being is that events like this, the CLEs we do, plus on the day-to-day basis as we mediate, it's all about educating people out there that they're not supposed to be recording things. And so if they were to somehow get a mediator, that maybe was not an attorney or even from another state, that they could say, hey, look, Mr. Mediator, Miss Mediator, you're not supposed to be recording these. So anyway, that's my 2 cents.
Thank you. Thank you, Sherman. Thank you. That's a very good discussion. I'd like to move on to our next topic, which we were
George,
going to.
I hate to
Yes,
interrupt. I have a
please.
quick question slash
Please. Yes, please
anecdote
do.
in
Thank
that,
you. Thank you, Irene. Hello.
sure.
Hello.
I think this it also extends to photo taking. And the
Yes, thank you.
reason for that is that in an opening session a few years ago, I learned a lesson in that in my opening session, I now ask people to please put down their devices. I say, if you're not an attorney, kindly either leave your device where it is or let's not be on our devices. We're going to focus on this conversation. I'm the only one who needs to talk at this time. So leave that where it is. Because in an opening session, and Deb is so right in that in the family law realm, we're often working with people with heavy personality disorders. So we have to be very nimble in reading the room and figuring out what's going on with people very fast. In about 2 seconds into my opening, one of the parties raised their phone, took probably 20 photos of the other party and texted them immediately out. I saw this
Ooh.
happen. I stopped my opening.
Ooh.
I graciously tried to gather what do I do next in order to deal with this situation, because one party melted into a panic attack, and I worked through that, and the other party had no qualms about what was happening. So I mentioned that because just having a device gives the opportunity not only to record, but to take photos or do other nefarious things that we all need to handle in the moment. So we just saying there's no recording or whatnot is not enough.
That's an
Irene,
excellent point.
that's a great comment. Go
Yeah,
ahead,
I think
Jackie.
we need to add no recording included with AI and no photo taking, because I have seen the phones go up like that, and I've had questions, and that's a nightmare. I think we should add that. Tara, is that possibly something that could be mentioned, a line in the AO? Or
I think it's so sad that we have to do this, but I do think it's necessary. And Deb Dillman just posted in the chat box that she's had people texting children about what happened at the mediation.
Same.
Adult and minor, doesn't matter. Like it's just,
oh,
it's wholly
So-
inappropriate. And you would think that people would behave better, but they don't.
Right.
We just revised this AO, but there's nothing saying we can't take it back through committee and say we have some additional considerations about photos, texting, everything that sadly we have to spell out to try to keep people on their best behavior. I think that we should definitely take a look at it.
Irene, thank you for that. That would be so disconcerting to have a party taking a picture of another party, particularly in y'all's family law area, if you're alleging some sort of domestic abuse and you're taking a picture of your ex-spouse and you're saying, doesn't she look great? I mean, that is such a good point. Thank you. So
George,
before
can
we
I
leave
ask
that,
a question
yes,
as
please.
well?
Please
Thank
do.
you. Good
Please
morning,
do.
everyone. So I don't know how unrealistic this is, and so this is why I'm asking. We talk about these devices and we talk about the things that we may or may not need. If someone, again, a non-mediator party or party to the mediation is present, is it unrealistic to invoke a Jeter rule? So for those of you old enough to remember, Derek Jeter was a player for the New York Yankees, and he never was part of a scandal. And the reason was because if you came in his home, the rule was you had to hand over your phone when you entered. Is that unrealistic in what we're asking for the participants? Would that be something that, because that would curb the issue? Again, it doesn't help you if you're laptop and such, but how unrealistic is it if we're asking the party to be present? You can have it back when the mediator's not in the room.
Can I take this one?
Yes, go ahead.
Please.
Okay. So we don't have anything on the books on how you all run your mediations. It's up to you. If you want to implement those rules, the only thing I would recommend is that you make it very clear in your engagement letter or email or scheduling notice, that those are your expectations, right? The one thing that gives me pause is that you may be able, if you're in person, it's a lot easier to do, right? To collect everything. You may have a lot of kickback though, especially when it comes to computers, because attorneys are going to want their computers there so they can draft. Parties may want their computers there so they can take notes and just keep track of everything, especially if you've got complex items that you're arguing over that involve numbers, right? But I think that it's a fair request. What I would say is that if you make the request and people don't abide by the request, you still have to do the mediation before the deadline, right? So it's kind of like trying to collect a retainer fee from the parties. You can ask for one, but if they don't give it to you, you still have to conduct the mediation under the rules, right? If it's a voluntary mediation, you can put any parameters in place that you want because that's your mediation wholeheartedly. Does that help?
On that note, I mean, I've always thought when I was on the DRC, is that I always tried to think of it from the participants' end, is that I always wanted to make mediation as participant friendly as possible, not as mediators, for it to be as easy for us, so to speak. There may be a trend out there. I was at a South Carolina conference. I'm licensed down in South Carolina and was down there. They're starting to require in the courtroom that all parties, even attorneys and anybody who walks in the courtroom, put their devices in Faraday bags. And so, that may be something coming up. But I'll be honest, if I was representing somebody and the mediator required us to put our stuff, to turn them over or whatever, I wouldn't use that mediator again.
Exactly.
And I do think it gets to a point, there's only so much we can control. We have to move forward. We just need to let them know that that's not allowed and then move forward. To Irene's point, she certainly had to, address that up front, but I just think we let them know and we move forward and we're not in control of them.
And if you look in the chat, there's a mention of the Meta glasses are now becoming popular. So, oh my God, Ken, we
It's
need to
everywhere.
retire. Oh my God. I mean, let's just go back to my fax machine. Jesus.
No.
I have extra toner. Thank you all. This segues, I think, well into Jackie. We were going to talk next, have you talk about the attendance requirement. And I'm particularly mindful of the rule that you quoted, Rule 4A2, that if you're conducting by remote, the mediator should ensure the parties are able to fully communicate with the other participants and video conferencing is encouraged. So that issue, Jackie, and also you mentioned attending by phone and other forms of communication. Could you carry the ball on that attendance issue for a minute?
Well, I think we did talk briefly about that at the CLE. I think the main thing we wanted to get to, I think we all know that we're to encourage attending by video, but that phone is allowed, and I think the main reason that was put into the rule is because there was a concern about folks not having access to Wi-Fi so that they could sign on with their video. Although now, I have to use a hot spot on my phone several times for Wi-Fi. But, I think one of the main reasons we wanted to address that is just the prevalence of, attorneys and their party. They are coming on by telephone as opposed to video. Because it's allowed, and it's just more difficult to connect when you can't, so if they're on the phone, their parties on the phone, their clients on the phone, and it's just more difficult to connect with folks if they're not on by video. Um, and so I think that, making it possible so that everyone can participate, to allow attendance by phone has been a bit of a problem for mediators. I'll have some attorneys, will then want to, call me when you come back to me. This would be mainly in comp, I guess, because the adjusters don't have to attend. Usually they're excused by everyone agreeing. They have to be available by phone standby. And so, you're losing some of that connection. I can't connect with the parties as well if they're on the phone. And I had one the other day where, everybody's on video, the day's getting late. I come back in one room and the attorney is still on video, but he was having to pick his child up from school. And then, it gets to a part where, it doesn't have any, connection. And then that kind of made his client feel like, well, I have an appointment. I'm going to go too. So I'm going to go. And all of a sudden everybody's scattering because they are still allowed to be available by phone, but then you can't get in touch with them. And so, that's just becoming an issue that I don't think we particularly anticipated when, going to remote. And so that's a problem. And I'm just kind of curious about how folks, handle that.
Ken, can I go to you on that issue?
Yeah, sure. I just say
Thank you.
That I would have already let everybody know that I'm fine with any agreement they have regarding remote participation. But if you're going to be remote, then you're going to participate. I mean, I say it in a nice way, but I expect it. I expect it in the opening statement, and I expect it in the other. And if they're not going to do it, then I get on them to do it, and they generally do it. And if they're not able to do it, let's just say the guy or gal's not able to be reached. I explain that to the other party. Usually they're fine with it as long as they're participating during it. So it's really hadn't become an issue. I just kind of lay it out there. I do it in the right way.
By phone? Do you mean by phone or video?
Yeah, phone, video doesn't matter. Remote to me is remote.
Well, you're right, but it's just frustrating. It's just more difficult to connect when they're just on the phone.
Yeah, but they're remote, and so there's only so much you can do.
Right.
And if they're participating by smartphone, they got video capabilities.
Right.
So I always ask them, unless that's a flip phone, is your camera not working? And I'll usually say something like, everybody needs to see those movie star good looks and all that kind of stuff. And usually they do it, and it's just really not a real issue.
Sherman, what's your experience with this issue?
Jackie and I have talked at length about this, just the two of us. At the end of the day, I'm getting paid by the hour. If somebody's hard to track down or they're taking a long time to call me back, I mean, I kind of at least take a little bit of peace of mind. Well, they're paying me even if I'm sitting here doing nothing. The biggest thing, though, that I just want to make sure it's not a reflection on me. When I first started mediating, I just kind of had said to myself that I don't want to be the type of mediator that drives me crazy when I'm representing somebody, which is the type that takes 2 or 3 times longer than I felt a case should, that they just hang out, tell war stories, and you're settling a $10,000 case and it's taking 5 or 6 hours. So I've always been very cognizant of the time that I want these to be done efficiently. And so that's where I kind of get into making sure that, the side that's not causing the delay understands that the delay is not being caused by me. And they typically understand because the attorneys know each other. It's like, hey, attorney A, I'm having a hard time track down. They're not answering their phone, or, they've gotten off of Zoom or whatever. So as soon as I hear back from them, I'll let you know, something of that nature or whatever. But that's the thing I try to make sure of, because, they are paying me by the hour. And if they want to be efficient and knock it out in 2 hours, that's one thing. If they want to take 3 hours or 4 hours because they're doing other things, I can't control that. But it is frustrating. I understand what Jackie's saying. I just don't know there's anything that we can do in this day and age. And most people are multitasking now. They may be on the phone with another client, or a fire's popped up, or whatever. So that's my 2 cents.
Well, and
Jackie,
I agree. It's not much I can do about it. I don't give them a hard time, but it is frustrating. But to your point, if let's say the attorney can't get in touch with the adjuster, and that happens a lot, it's like, oh, they've gone to lunch. Oh, they've left for the day, that sort of thing. I mean, it's an interesting point, though, don't let them know, but I'm still trying to get in touch with them. I can't get in touch with them. And so, do you go into the other side and say, well, they can't get in touch with their adjuster? I mean, I think you have to be careful about that and just, keep pushing them, say, try to call them again instead of I've emailed them, so that's a fine line walking.
Jackie, I'm sorry, anybody else want to chime in? No. Jackie, when you quote the comment to Rule 4A2, it implies to me that part of the competency of the mediator is the ability to know all this technology stuff to make you, in other words, the comment says that the mediator ensures the parties are able to fully communicate with everybody. So that means understanding how you create separate breakout rooms, right? You got to understand how that works. So you got to be sure you're talking to the right side. Do you agree with me on that? That there's a duty of the mediator to be competent in this area?
Well, excuse me. Standard 1 talks about competency, and so I guess the question is, does that go to the mediator's ability to use the platform that they're conducting the mediation with? If the parties are having to wait for the mediator to figure it out and it goes 30 minutes, 40, that's it, is that a problem? Does, competency goes to being able to mediate, to understand the rules and the standards. And I guess one question would be, does that also go to being able to use the platform? I don't know. That's
Exactly.
something Tara's going to have to weigh in on, but I do think that we have a duty to understand how to use these platforms that we're telling the parties to use.
Which is why in June we're going to talk about technology as it affects mediators. Sherman, would you comment on that? And then I want to go to Tara.
I was going to follow with what Jackie said right there. I mean, I sometimes feel like, I'm an extreme capitalist or whatever, but I think the marketplace determines a lot of that. Is that we've got attorneys that are coming in to choose us, and if they choose us, they're choosing us for not only our legal expertise, but what's our ability to do it. And I've been mediating for over 25 years, and it has substantially changed. I mean, it used to be, you showed up in somebody's office with a piece of paper and pen, and now we're doing things like this and stuff. And the attorneys, that I used to deal with were older than I am. I'm 60 almost. The majority of the attorneys I deal with now are younger than I am. They're coming in their late 20s, and they're very sophisticated, and that's their default, is using technology. They're the types that would get nervous if we all got into a conference room together. So default is that way. And so if I'm with these younger attorneys, and if I can't keep up with the technology, the marketplace is going to determine, they're going to say, hey, you know what? We're going to go use attorney mediator B instead of Sherman, because he just doesn't know how to do DocuSign. He doesn't know how to set up these breakout rooms and stuff. So, I mean, we can come out with the rules, what our responsibility is, but at the end of the day, the marketplace is going to determine who the attorneys and the parties are going to use as the mediators.
Yeah, well, let me go to Ken next. Ken, do you want to weigh in on that, being of the fax machine generation like me?
Listen, I date pre-fax. I go back to mimeograph and so, and Sherman, if it makes you feel any better, you are a young man to me. Okay.
Yeah, me too.
There's a few on the call that could say that as well, but not many more. Yeah, we got to keep up with it. I happen to be pretty comfortable with it. I had to because I still teach at the Wake Law School too, and when COVID hit, I had to transfer everything to Zoom. So I learned it to a level that I never expected to learn it to a level, and it was a very easy transition for me. But yeah, you got to know it, and you got to stay abreast of it, which I think is why we're having this conversation about AI. We're trying to get ahead of that curve. So,
Very good.
yeah.
Tara, is the commission gonna help us understand tech better, or is the burden on us mediators to do that?
A little bit of both. I mean, we are learning just as you all are learning, right? Of how to use the new technology that's coming out, and we really rely on those of you that are in the trenches to keep us aware of the technology that is occurring. I'm pretty sure I've never heard of meta glasses before, so I made a note that I need to Google that to figure out what they are, right? So the information that you all give us as feedback really helps us stay on top of it. We have a bunch of free tutorials, if you will, that we put up on the website during COVID of how to conduct remote mediations, how to do a telephone mediation, how to kind of navigate technology. Granted, they're probably all outdated at this point because they went up, 3-4 years ago. But it'll at least get you a start. And then something else that we love to offer is for mediators who are just now jumping into remote mediations, our staff will actually schedule and hold a mock mediation so mediators can practice breakout rooms and how to set up the invitation so it automatically has the parameters that they want before they even get started in the mediation to make a mediator more comfortable, because I think this does speak directly to competency, right? And that standard has always been seen by non-mediators as legal competency, but it is anything but. It is the technology that y'all need to be up to speed on, right? And we still have the ability for mediators to select that they will do in-person only if they don't want to mess with the technology. That's fine. But the reality is that the majority of mediations that we're seeing right now are being done through technology.
Yeah. And George, let me add another comment if you don't mind. And this is kind of big picture stuff. In a weird way, COVID really had some positive impacts in terms of the ability for companies and organizations to pivot and to pivot quickly. In my regular legal practice, I represent companies and employment issues. And I can't tell you the times we had conversations with companies that said, we had a 18-month plan to pivot to more remote work and all this kind of stuff. And they did it in 3 to 6 weeks. They made more mistakes, but they did it. And y'all remember, anybody who was mediating before the year 2020 knows it took an act of Congress to have anybody participate remotely in any way. It just wasn't allowed. And within a month or two, it became the norm. So it's amazing how, when new technologies and new socioeconomic things happen, it's amazing how adaptable we can be. And so, I hope, the DRC and anybody else who's on the regulatory end just kind of recognizes that change occurs. And when change is forced upon us, we really make the changes. And sometimes you can get ahead of it and not wait for it to be forced upon you. But change can happen, and it can really be positive.
Very good. Very good. Thank you. I noticed in the chat that Frank is about to go to Black Mountain to do a mediation, and wish I was going with you to watch. But Frank, it's always great to have you join us. We've got just a few more minutes to go here. Jackie, next on our agenda was MSC Rule 7, compensation of the mediator. And you've had some interesting experiences with you yourself getting paid. Would you lead us off on that? The compensation issue, an important one.
Let's see, looking back at the outline. So, I think there's one thing that Sherman and I have talked about, and this is not so much about getting ourselves paid, but when you stop billing for DocuSign, bless you, whoever that was. you send out the document, and I do not let folks leave until the document's signed. I learned early on. I had somebody went out to dinner so they could celebrate their settlement, and they had not signed the document, and so trying to track them down, and so I'll just say, you got to stay. Everybody wants to leave. They want to leave. And I'm like, no, you got to stay until we've all signed. And that does speed things up. But I did have one defense attorney drop off, and, I was texting her going, I sent the DocuSign. And then she's like, oh, I'm picking my kids up. Oh, we're having dinner. Oh, I'm putting my kids in bed. She got this on her telephone. And I was like, I need you to sign this. And she finally signed it. And so, it took me several hours to get her to finally sign it. And, it was very frustrating. Obviously, I did not continue billing, for that. But then, how long I've had some mediators say, I don't stop billing until that completely signed document comes back. Well, if I'm working and they're in the room and I'm like, yeah, make sure you click on this or whatever. Or maybe the attorneys will say, I'm going to print it off, clients in the office with me. I'll get it, the ink signature. I'll scan it back. You can put it in DocuSign. You're waiting for them to do that. So I don't know. I kind of play it by ear. I don't let it go too long. But if I am really working to, get it signed, I'll continue billing. Now the defense attorney will say, you keep billing until that document's signed, and because obviously that's what they're doing. So I don't know. I thought that was kind of an interesting topic.
Definitely. All right, Sherman, are you going to piggyback on that for us, please?
I can, Jackie and I have about that. A lot of times we're dealing with insurance companies that are ultimately paying our bill. And so you'll have situations where, you think you've got the agreement done, you send it around to the parties and you think you're done. And then 30 minutes, 20 minutes later, you get a email back from the parties like, hey, I was reviewing this with my client. We need to make a few edits. And so then you got to go back. And so clearly, you're continuing to bill for that. And then the document, finally gets done. So you got to be careful with that. But I think the real situation that Jackie and I were discussing is that a lot of times there may be situations where, you're sending the document around and there's just an incredible long delay, whether it's an hour or two. And then the attorney may even say like, look, I've got to swing by and pick up my kid. And then I'm going to talk to my client later and we'll go over it and that kind of stuff. So I do remember before we had all these Zoom mediations and stuff, like 10 years ago, 15 years ago, there was a situation where like, I think an attorney, the issue came up where they were billing more time the mediator had submitted on a bill, and they kind of got called to the carpet on it and stuff. And so, and I was a former defense in my first life. And so I've always been cognizant of trying to talk to the attorneys at wherever the conclusion of the mediation is when we have a document is to confirm that my time is going to match the time that is being submitted to the client, because I don't want the attorney to get, in trouble for saying, hey, how come Sherman's, an hour less than what yours is, or the flip side to be the case, that if I feel that, okay, I was still potentially mediating this and I've billed to when the plaintiff finally signed, and then the defense attorney is submitting something that's an hour less. And so, I'll text them and say, look, how much time are we putting down for this? Because I want those two to be the same. So that's just a practical thing. And maybe some people, have a problem with that. Maybe they say that you should independently determine what theirs is. But again, these are people that I'm routinely mediating with over and over. And so I just want to make sure there's a consensus there. That's my practice.
Ken, what do you do in your mediations where you've reached an agreement, but you're told that the board of directors has to sign off on it, or a comp mediation I did where They were going to create a new position for this fella, and the county board had to meet. We have an agreement, but does your clock stop? How do you deal with that issue, Ken?
Yeah, my clock generally stops, and I'm kind of like, I think it was Jack who said, but probably others as well, that I keep everybody engaged till I see signatures. Now, normally it's the first signature that I care about, and it's primarily the plaintiff's signature, because every now and then you got, let's say the company president has to sign, and they're not participating. They got the VP of HR, somebody like that in there. And so I just stop the clock with the first signature. If in fact it's something that's being, I guess, for lack of a better term, being held open because it's subject to board approval, subject to something else, I don't certainly charge for any of that dead time. And I usually don't even charge for when they get back with me and they say, look, everything's been done, unless I'm really getting re-engaged again. But I'm not doing my mediator's report until that final step has been made if it's subject to those kinds of things, because of things we've already discussed before and what the requirements are, if you're going to report something settled, it better by God be settled. So, but I will say this as well, in terms of the kind of mediations that I mostly do, it's absolutely amazing to me that even some of the most experienced attorneys come thinking, well, this is never going to settle. I might plant the seed with them at 4 o'clock that it's going to settle. You might want to have you brought a draft settlement agreement, because usually it's the defense that's doing it, and it's like the light came on from heaven or something, and so they do it, and then it takes 3 to 4 hours to get that thing done. It's just absolutely amazing to me. And I will often, frankly, I will bill for part of that. But let's say it's getting ridiculous, and I'm on Zoom, and I'm just, I'm not doing anything. And so I'll often not bill for at least a good part of that time. And they always love it when I say, okay, I'm going to cut my clock off at this because I'm really not doing anything. And despite being a lawyer and loving being paid for not doing anything, I just can't do it as a mediator. And they generally laugh or something, and we get past it. But yeah, I cut them some breaks. But it's amazing to me how inefficient that process can be with even experienced attorneys.
Yeah.
Hey, George, can I tell a story?
Tara, jump in, please.
Okay, so this is a good story because we only have a few minutes left, so it'll be food for thought. Had a situation where a very skilled, knowledgeable mediator conducted a mediation and left the mediation with consent of all parties to finalize the agreement. So mediators stopped their billing, went and did their thing. The parties were trying to get the final document signed. The mediator was right along with the rules, reached out to all parties. Hey, if I want to call this settled, I need that signed final agreement. Got no response from the parties. Mediator waited a couple more days, sent out another email. Hey, I need that signed final agreement if I'm going to report this as settled. Got nothing from the parties. So the mediator got onto Enterprise Justice, right? Yay, everything's online now. And saw that the parties had submitted a consent order to the court. So the mediator reported it as settled, right? Anybody see an issue with that? All right. Did not see the signed final agreement. The problem with that is the report to the court told the court that the mediator did see the signed final agreement, which was signed not by the parties, but the attorneys, right? This takes us back to Mitchell. And the whole reason why we now have within the rules the ability for a party to designate someone to sign on their behalf if the mediator sees it in writing, right? So the reporter mediator is telling the court, I have written confirmation from the party that their attorney has authority to sign on their behalf. There's currently a motion to set aside that consent judgment pending. I'll let y'all know how it turns out. So,
now there is, Tara, I'm curious about that. A quick question here. So there is a part of the reporter mediator for Superior Court, the reporter mediator, that says if it's settled afterwards and report who said that it's settled, And in that, but in your situation, they never heard from the
Never heard.
parties.
Mediator assumed
Yeah.
they
Oof.
agreed. Rough
Oof.
one, right? And
Yeah.
so here's the trick is that the mediator, super intelligent, knew the rules, knew how things were supposed to work, thought they were doing the right thing, right? But that one little trick has complicated the whole thing, right? So I'm fine. The DRC, I should say, is fine with you all taking as much time as you need to get that final agreement done, whether you recess and reconvene, or whether you take a break, or whether you just hang on for 20 minutes to get them back on the phone. But it is the mediator's responsibility to see that signed final agreement before they call it settled.
A cautionary tale.
Cautionary tale.
So,
Hey, Tara, let me ask you something real quick though on that. It kind of goes back to what we talked about before when you're holding something open for court board approval or something
Mhm.
like that. Okay. Well, one of the forms, and Ann Anderson can relate to this very much, where we'll settle an age discrimination case that might be subject to the Older Worker Benefits Protection Act, which is a 7-day revocation period. Okay. Now, one way that certainly I've done it, and I think Ann's done this before, and others who do employment law, is we put a little asterisk next to settle, and it'll say subject to OWBPA requirements or something.
Can't do it.
And that would be in federal court. These are federal, but are you saying don't be doing that either? Wait until
It's technically
Yeah.
it's contrasting with the standards, right? So even though federal court's not under our rules necessarily, it's providing more
Right.
information than what is required. And the commission did take this matter up, talked about it for a long time as to whether or not we wanted to amend the current reporting mediator to allow for mediators to report subject to final approval by board, by city, by township, by
Right.
whatever. And they determined that it just was not necessary in the sense that it would be so hard to create the exception, and it would be very hard to draw lines around it. And we have a lot of judges and retired judges on our commission, and they all said the attorneys can report it, the mediator can stay out of it. And so they declined to take it up and to do anything. And they have rested on the position that if you do not have final agreement, meaning somebody has authority to kick it, then you have to call it
Yeah.
an impasse unless you can get an extension of the deadline.
So Tara, may I jump
Okay.
in since my name was mentioned?
Please do.
Sometimes,
Call your phone, Ann.
yes, and I know we've had this discussion. Because sometimes what I have said is subject to statutory requirements. So it's not an approval, it's a time period passing. Rather than having somebody agree. But generally, of course, that's going to be in federal court. And then the other question is, if you have a signed agreement, the only thing that's going to jump in or make it ineffective is the passage of time or something that is a legal assessment. So you've got the signed agreement by the parties. The parties assume it's settled, but there's just simply the statutory overlay on the agreement.
Right. So so you all know that confidentiality is really tricky. If anything is public knowledge, that's fine, right? So if you put on there subject to statutory or subject to statute blank, and you don't indicate any additional information, like defendant is waiting on, right? That defendant is waiting on is what's going to get you into trouble, right? It's just like if somebody filed a bankruptcy, you can put on the report of mediator, mediation not held, bankruptcy has been filed, because that's something that you can find through the courts, through enterprise justice. So I think I would be fine with that. I think the trick is whether you call it settled or not settled. Court staff have indicated to us that they do not want those called settled because there is still a very slight chance that that case is not in fact going to settle. And this is Superior Court and District Court, not federal court, right? They may want something different. But if you're in federal court and the federal court staff want you to go ahead and call those settled, that's between you and those courts. But on the report that you send them, I would just simply put subject to and then list the statute, because that's not providing any confidential information. It's just providing facts, right?
Well, that's precisely the case with the OWBPA. I mean, that's a regulatory, if not statutory requirement. That's saying the same thing, just saying what it is. So why wouldn't why wouldn't that be good enough then?
Well, no, I'm saying that it's up to the courts as to whether that's good enough. And for confidentiality purposes, if you keep it so vanilla that you just
Yeah.
mentioned subject to statute, you're not giving any information. But if you say defendant, so case is settled, but defendant is waiting on this group under this statute to sign off, that's giving too much information. It's a fine line, right? And it's nitpicky for sure. But my job is to give you guys advice that will keep you out of the mud. So I'm going to be much more narrow in everything that I say, right? If you all want to extend those leaps, go for it. But if it comes back on my desk, don't get mad at me if you get a letter saying, hey, Ken, stop behaving badly, right?
Yeah.
So
absolutely.
I'm going to keep it as tight as I can just to keep everybody protected, right? I'm like, I see our office is like the bubble wrap that we want to put you all in before we roll you down the streets, you know?
George, I know it's time to get off, but can I quickly ask Tara, how
Yes.
did that case come before the DRC where the consent judgment had been filed? The attorneys were crickets to the mediator's efforts to find it out. The parties weren't complaining to DRC about it. They wouldn't even get back to the mediator. And did the mediator contact DRC, or was there a self-report, or how did DRC find out about that situation?
Oh, about my cautious tale?
Yeah.
Yes.
Yeah. Oh, no, the party who's filing a motion to set aside the consent order is
Oh, okay.
they are
Okay.
hot,
Thank you, ma'am.
right? Because the mediator's
Right.
report is messing with their ability to get that
Okay,
consent order
thank
set
you.
aside.
Thank God. Thank you,
Yeah.
George.
Judge, thank you for that question. You all, it's 9:31. Thank you all for joining us today. This has been a fantastic discussion. We will be back to you again in June. And again, thank you all very much. I've learned a lot just listening to all of y'all. Have a great day, and we'll see you all soon. And if you have any complaints or comments, please send those to Sherman.